Hello, Salil. Welcome to the first episode of our web series, Simply Legal. I'm glad to have you with us on the search. So, without wasting any further time, let's get on with the topic. What exactly is a will?
First thing is, Rahul, I'm glad to be on this web series, Simply Legal, and I wish you all the best. Coming down to the topic, we all know the term willpower, but many times we ignore the power of will. Will isn't a legal, will in its legal manner can be said to be a document by which disposition of a property is done. Actually, will is the last wish of the deceased.
Okay. Can you elaborate a little bit further?
Sure. Under the law, we fairly distinguish devolvement of the property as per the personal law or by will. The personal law describes devolvement of ancestral property. However, in a will is an instrument whereby the distribution of the self-acquired property is authored by the testator.
Okay. What is estate and in-estate property?
The succession law of India generally differentiates between estate and in-estate property. If a person dies in estate, that is without making a will, personal law comes into the effect. And if a person dies making a will, then his wishes are to be executed in accordance with his will. Now, in case person dies in estate, in that case, letter of administration or succession certificate comes into the picture. This also happens in case of will wherein the administrator is not appointed.
Wait. Tell us what is a letter of administration.
Let's understand what is the letter of administration. The competent court, upon an application, grants a certificate. This can be done in a situation wherein will fails to appoint an administrator.
But why is an administrator required?
The simple answer to this is that the testator, that is the author, is no more, and to execute his wishes for his administration of his estate, an administrator is required.
Okay. What is a succession certificate and what is it used for?
Succession certificate is like a letter of administration. A successor has to approach to the court and request for the succession certificate. Unlike letter of administration that is ordered and handed over by the court. Succession certificate is used to pay the debt, transfer securities, to inherit debts and securities. However, these things can be done only by legal heir upon the grant of succession certificate. Or rather, instead of word legal heir, I'll use the successor, word successor.
Okay. Can you briefly explain the process to get a succession certificate?
Well, it's not a very complicated process. The place of death shall be the jurisdiction of the competent court in that area and shall grant the succession certificate. A petition is to be filed giving details of the time, place of death, family, relatives, rights of petitioners, and other details. Upon the perusal, the court may grant succession certificate. Over here, the court may ask to furnish security, surety, or a bond, as the court may deem fit.
Okay. What does letter of administration do?
By letter of administration, court entitles the administrator with the administrative rights that effectively and helps smooth administration of the property of the deceased.
And who can apply for the letter of administration?
See now, as per the Schedule 7 of the Indian Succession Act, there is a requisite form. After 14 days from the death of the deceased, it can be preferred before the competent court, which such letter of administration can be granted. If no one applies then the letter of administration can also be granted to the creditor.
Okay. Now tell me, what are the important aspects of the will?
Corpus juris secundum is a commonly known as will. Now, notarization or a stamp paper is not required for that. It can be revoked at any time. Sounds simple. However, it is essential to understand the legal aspects. Haphazardly, shoddily written, and unclear thoughts will create a will which would be difficult to interpret. It is also a question that credibility of the will. The will should be incorporated as per the provisions of the law of time being in force. The testator can include movable and immovable property of his own.
And who can keep this will?
Uh, I'll tell you one thing, that a will can be kept with the registrar for safe custody. However, if the testator wants, he can keep it with him or can entrust it with to keep it with his attorney or any other person.
Okay, that's great. Now, can you tell me how many types of will are there?
Uh, See now, primarily there are certain types. One of them is a conditional will. This conditional will is one which depends upon the fulfillment of certain conditions. A joint will can be made. A joint will wherein two or more person, like husband and wife, can make a joint will. Then there is mutual will. Mutual will is between two or more individuals reciprocating benefit. They are actually two indentures. Privilege will is another part, but it is related to armed forces.
Okay. Who is a legal representative?
Over here, with the aspect of legal representative, it is pertinent to understand that the expression legal representative as used in the Code of Civil Procedure is not confined to heirs, executors, or administrators of the deceased person. It has been held to include a person, though not an heir, executor, administrator, holds an estate in another capacity, such as adopted by such as a son adopted by a widow in relation.
Okay. What are the things one can do with a will?
See, property can be passed to a charity, passing on of amnesty or charity and business, appointment of guardians in case the beneficiary is minor or is suffering from any mental disease. Then passing on rights to collect rent.
Okay. Now, let's discuss, or could you just explain some important parts of a will?
Hmm. Now, this is a very important question uh, and needs to be handled with care. Now, first part is codicil. Codicil is an explanation or alteration or adding up of something to the will, whereby reflection of life is given. A codicil can substitute a new executor. It is a part of will and it is read together. Then there are some people known as beneficiaries. Beneficiaries cannot be the witness of the will. Beneficiaries are usually the family member, wife, children, grandchildren, etc. It should be taken into consideration the death or disability of any kind. In such cases, an administrator or a trustee can be appointed.
Okay. Tell us some important points regarding drafting a will.
It is important to specify detail of movable and immovable property and shares to the heirs. However, just because certain words are not used, or if certain facts or details are not included, it does not mean that will is invalid. Will can be on a plain paper and not mandatory to be notarized or registered. Ideally, a will should accompany with a medical certificate and should be signed by the two independent witness along with their affidavit and should be registered. A new will automatically revoke old one, but such revocation should be a part of the codicil. While dealing with movable and immovable property, it is better to give a description. If details cannot be provided in it, words like bank accounts should be used so that all accounts, it's a general terminology, like bank accounts are taken into consideration. It is very significant that residual clause to be added in the will. Now here, what residual clause does is that it allows attorney to cover what is not explained in detail.
Okay. So tell us who is an executor and what's its role?
Uh, an executor is not a beneficiary. However, he or she is a person who is assigned almost everything, right from arranging funeral to locating beneficiaries, collecting debts, process of legal procedures which are involved. It is therefore very important to appoint an executor.
Okay. When we talk about will, we hear a lot about this word probate. Can you tell us what is a probate?
Yeah. A probate is a official proof issued by the court. Under this seal of the court, the copy of the will is declared authentic. This gives a testator a legal character. A probate can be applied before the High Court, having jurisdiction after 7 days of the death of the testator, along with the will, the copy of the will. Death certificate of the testator is to be submitted. Court examines the validity and the consents of the testator, sends notification, notice is published in usually in English and regional language. Upon being satisfied that there are no objections raised and there are no impediments, probate is granted. Stamp duty for the probate is based upon the value of the property.
Okay. Well, to sum it up, the will though seems to be a simple document, but requires a lot of things to be taken into consideration. As we just heard from Advocate Salil, it is always better that it is being drafted perfectly to capture the wish of the testator. Thank you, Salil, for explaining us about this document called will, and I'm sure your explanation shall help our viewers to understand about will and its importance.
Pleasure is all mine.
Yes. With this, I conclude our first episode of Simply Legal. Please don't hesitate to like this video and press subscribe if you wish to see more such videos. Your support encourages us to bring more valuable guests and quality content for you. Thank you.